Good evening. Thanks so much for joining us tonight. My name is Yael. I'm the Community Relations Manager here at the bookstore. And tonight's event is part of a series of events that we hold here, featuring authors both from NYU and from other far places like Boston and Harvard, Cambridge. We're really delighted to be featuring Carolyn Light this evening. Carolyn is the author of a new book, Stand Your Ground, A History of America's Love Affair with Lethal Self-Defense. She will be joined by NYU's Professor Anne Pellegrini, and they will be talking amongst themselves about the book, and they promise to make it very lively. I think that we can say that. Caroline will also be reading from the book, and then we'll have a Q&A session. So just a quick introduction. Let me put my glasses on. Yes. Caroline Light is Director of Undergraduate Studies in Studies of Women, Gender, and Sexuality at Harvard University. She's also the author of a previous book from 2014, That Pride of Race and Character, The Roots of Jewish Benevolence in the Jim Crow South, which was published by NYU Press. Anne Pellegrini is Professor of Performance Studies and Social and Cultural Analysis at NYU, and she's also the Director of the Center for the Study of Gender and Sexuality here at NYU. It's with great pleasure that I am here to welcome both of you and welcome people here in the audience. Thanks so much for joining us, and let's have a little applause for very important topic that I think is very timely to all of us. Thanks so much for being here, and please welcome Caroline Light and Anne Pellegrini.
Thank you. Thanks so much, everybody, for being here on a school night to talk about somewhat demoralizing things. And I want to thank NYU Bookstore for hosting me. It's a real honor to be here, and especially to thank Anne Pellegrini for engaging in this conversation with me and inviting me into her classroom today, where we had a really interesting discussion with her students about the legal roots of contemporary lethal self-defense. Anne has actually been an intellectual influence in my work for the past couple of decades. Obviously, she's a prodigy.
When I was 5 years old.
She was 5 years old when she published her book, Performance Anxieties, but a lot of the work that I do on racialization and structures of legal and epistemological exclusion are directly derivative of the work that she's done. So I want to thank her for that. So where should we start?
Well, you know, the book is so topical. I mean, and I guess I wondered, what can history offer, right? So this is a book that you began writing sort of the same after the death of Trayvon Martin. So in 2012, we hear still far too often about the lethal use of force against young black and brown men in particular.
Yeah.
And so this is a topic that's in the news all the time, but how can history help us think about which subjects may be targeted for death with impunity, and who gets to weaponize fear?
Yeah, that's an excellent question. And so sorry, can you all hear me if I stand? Okay. I'm obviously trained as a historian, so typically when I try to look for answers to urgent social issues in the contemporary universe, I tend to look into the past to try to understand what's the genealogy of this way of thinking. In this case, the weaponization of fear, as Professor Pellegrini just said. And for me, I was very surprised by what I found when I started looking back into legal doctrine, not just of the United States, but prior to the instantiation of the United States, English common law doctrines that endowed particular kinds of social actors with the privilege of using lethal self-defense in particular circumstances. So one of the things that I discovered that I found really interesting was the roots of the castle doctrine. When you look at stand your ground laws, which are now a reality in different iterations in 33 states in the United States, so they vary according to the state, but they're often referred to as castle laws. So this invocation of that old adage, a man's house is his castle, really haunts the sort of justification of these stand your ground laws. The idea that you have a right to protect yourself in your home from danger without first retreating. However, it's misleading, it's ahistorical, because truthfully the castle doctrine is about your right to protect yourself in your home. And stand your ground laws endow people with the power to fight back with lethal violence in public spaces beyond their home. And it is actually selective in the way stand your ground laws are adjudicated. So as we've seen with, as you mentioned, Trayvon Martin, but also with others like Marissa Alexander as well, stand your ground laws do not apply evenly to everyone. They're very selectively enforced. So I would say one of the lessons of history is to show the inaccurate way in which stand your ground laws get promoted as being a universal appeal to the safety of everyone's castle.
So if the initial premise is that within your own home, you, and the you might not just be just anyone you, but the owner of the home, the property holder, has a right to defend himself and his family in his own home, how does it move from being located in a particular private space to being something that is, I don't know, portable? You get to take, some people get to take it with them into a public space such that they can defend themselves in a park, for example, or a roadway.
Right. It changes a lot in translation from England to the United States. So one of the things I try to show in the book is how this idea of lethal self-defense and the castle doctrine shift in space and time. So, for instance, it's in the early republic in the United States that the duty to retreat begins to get undermined in a serious way through certain legal battles.
Can you say a little bit more about the duty to retreat? What did that command someone to do?
So the duty to retreat was one of the central legal doctrines in English common law. It was that if someone was attacking you, you did not have a right to fight back with lethal violence until your, quote, back was up against the wall. So you were supposed to try to get away as much as you could before you fight back. The one exception to that was the castle doctrine. That gets instituted in 1604, that in a court case in England, where we get this old adage, a man's house is his castle. So the castle doctrine then provides an exception for someone who's attacked in their home. But originally, there's a duty to retreat, and that duty to retreat also exists in the United States. And I argue too in the book, I show in the book that the duty to retreat wherever you are still exists for certain social actors, and they tend to be those social actors who are most vulnerable politically, economically, etc.
But so how does, if the notion of a duty to retreat, except in the limited space of the house, comes to the United States, or comes to the U.S. The colonies that become the United States, how does it expand? I mean, what are some moves? Because this, I mean, I think one of the things that you're doing in the book, and this is where history, thinking about this historically is so helpful, you're kind of showing that the obviousness of certain conversations we have now about self-defense, it's not obvious at all. No. It happened through a set of sort of legal actions, social actions, kind of, then it gets knit together, so it seems inevitable afterwards, but at the time it wasn't.
It isn't. No, it really isn't. I mean, there's a section I can read that sort of lays the groundwork for this, but I show in the book that there's a certain set of cultural, economic, political circumstances that come to bear in the United States on that duty to retreat, and that in the end make the duty to retreat incommensurate with white masculinity and with the priorities of manifest destiny. So ultimately, this duty to retreat is completely incompatible with the, for instance, the spread of the nation from one coast to the other. It becomes incompatible with white masculine honor. And I show that through different kinds of court battles in particular, because the law provides a particularly salient archive when you're looking at the ways in which different laws get adjudicated for different kinds of social actors. So what was true for one kind of social actor would not be true for another.
You talk about the case of Thomas Selfridge.
Yeah.
Right, from the early 19th century in Boston. And could you tell us about that case? Because this is such a kind of like the moment of this movement, this sort of expansion of the duty to retreat.
So, so the case of Thomas Selfridge happens in Boston, and it's, I think it's within 2 years of the infamous killing of Alexander Hamilton by Aaron Burr. So it's just within a couple of years of that. It is not, it doesn't become as famous, but it becomes a landmark legal case that gets referred to in later 19th century cases about the duty to retreat. So I could, do you want me to read the section on this? Okay, so this is early in the book. And it starts with this trial. So when Thomas Selfridge stood trial for manslaughter in December 1806, the young nation's laws were vague on the topic of lethal self-defense. This 32-year-old lawyer had killed a man in the streets of Boston, claiming that he did so to protect himself from grave danger. The English common law on which United States legal foundations were based held that one must withdraw in the face of an attack and not retaliate until retreating as far as he conveniently or safely can. The crown, or the king, held the capacity of vindices injuriam, of vindicating or avenging the wrongs that citizens inflicted on one another, and accordingly, the taking of another's life was among the most serious of crimes, one commonly, perhaps ironically, punishable by death. Yet in the United States, the idea of backing away from a threat or of allowing the government to protect one from harm clashed with the ideals of independence and individual rights on which the nation was founded. And while the race of the men at the center of this landmark case went unmentioned, whiteness and masculinity, along with property ownership, were as critical to the distribution of political rights as to the right to defend oneself. While legal doctrine upheld a duty to retreat, popular opinion in the young republic increasingly saw a white man's retreat from an assault, especially an assault on his honor, as cowardly, as incompatible with the values of liberal democracy. So I talk a little bit about how Enlightenment thinkers like Thomas Hobbes and John Locke challenged the monarchy's monopoly on lethal punishment. In 1651, Hobbes was the first to invoke an inalienable right to self-defense. He wrote, "A covenant not to defend myself from force, by force, is always void." And in his second essay on civil government in 1690, Locke invoked self-defense as that great law of nature. He argued, "Whosoever sheddeth man's blood, by man shall his blood be shed." So I mentioned before that the exception to the English duty to retreat was the castle doctrine. That originates in a case in 1604 and popularizes the notion of a man's house is his castle. But while there's no reference to the race of the man authorized to defend his castle, in practice, this castle doctrine originates predominantly in the context of white property owners, predominantly white men. In the United States, the legal conditions that exclude most women and non-whites from access to political and economic rights and property ownership guaranteed that the castle would serve as a safe haven for white men and their property. So I go on to talk a little bit about the legal doctrine of coverture, and we talked about this in your classroom. Coverture is essentially where, under British common law, when a woman got married, she relinquished all of her political rights to her husband. Essentially, as Sir William Blackstone writes, the very being or legal existence of the woman is suspended during marriage, or at least incorporated and consolidated into that of her husband, under whose wing, protection, and cover she performs everything. So hence the name Coverture. The castle that a married woman occupied belonged entirely to her husband. So the central mythology of this is that the married woman lives under her husband's protection within his castle. Coverture has a lot of social implications. One is that a woman could not defend herself from an abusive spouse. The law allowed husbands to discipline their wives through the right of chastisement or physical punishment. According to Blackstone, a husband, quote, might give his wife moderate correction, end quote. The only exception to the masculine monopoly on violence existed when a white woman protected her chastity. And this had to be from a stranger too. So there was no such thing as marital rape. This was not, there was no acknowledgement of marital rape. When a woman said "I do" to marriage, she essentially consented to sex whenever her husband wanted it. In fact, in this nation, marital rape was not outlawed until the 1990s. So this is another, I would say, a legal fiction, in the words of Carla Holloway, who writes about the intersection of literary knowledge with legal knowledge. There's this right to protect her chastity. By granting men full authority over their wives and their daughters, the doctrine of coverture coexisted harmoniously with settler colonialism and legalized slavery. So I talk about the way in which the legal doctrine of coverture is also interimplicated with legalized slavery and settler colonialism. The legal immunities of the Castle Doctrine and a woman's defense of chastity did not extend to Native Americans and African Americans unless they were free property owners. Like coverture, slavery and settler colonialism rested on the belief in the supremacy of Christian men of European descent and their necessary control over other human beings. The law allowed masters liberal discretion when it came to disciplining their slaves, and most slave-owning states prohibited African Americans, free as well as enslaved, from owning weapons. While a few of the laws punished masters for outright killing their slaves, usually murderous or abusive slave masters received scant discipline by the law. The number one incentive preventing a master from killing his slave was his monetary investment in the slave's labor. Living at the intersection of white supremacy and patriarchy, enslaved women could not legally defend themselves from most forms of violence. Valued for their labor and reproductive capacity, which contributed to the owner's workforce, enslaved women played a vital role in slavery's sexual economy. A slave's sexual consent was made irrelevant by her status as chattel, as property, rather than person. As legal systems that undergirded the young nation's social order, coverture and slavery existed in structural interdependence, ensuring that the most valuable property remained under the control of white men. Legal doctrines governing the hierarchical relations of husband and wife, of master and slave, were inextricably connected. Thus, law and custom conspired to exclude the nation's most vulnerable from the legal right to defend themselves. So that's the historical context in which this case with Thomas Selfridge takes place. Selfridge was a devoted Federalist, and he got in this major feud with a man named Benjamin Austin, who was a Democratic Republican, or the party of Jefferson. He published a statement in the Boston Gazette calling Austin a coward, a liar, and a scoundrel. I won't get into the details. They were fighting over a catering bill.
He'd be tweeting it today, right?
He would be tweeting it.
At 3 a.m. probably.
Absolutely. So this was a really provocative kind of gesture, and it resulted in Benjamin Austin threatening to send somebody to settle the score with Thomas Selfridge. Selfridge armed himself with a pistol, because he was described at court as being weak and infirm. He said to one acquaintance that he was not fit for bullying or fisticuffs, but he was prepared to defend himself. That afternoon, on August 4th, he was walking towards the public exchange on State Street, where he encountered Austin's 18-year-old son, Charles. Charles Austin was a sturdy, athletic young man, a Harvard student, and at that moment he was rapidly approaching Selfridge with a cane in his upraised hand. And witnesses disagree over who made the first assault, but the end result was that Selfridge fired, killing Austin, and Selfridge was taken into police custody and arraigned for manslaughter. At the end of the legal battle, so this case goes on for quite a while, it receives a lot of sort of popular interest, and especially because it was political, because it was between these warring parties or members of these warring parties, it did receive a lot of press. Also, Paul Revere was on the jury, which I find fascinating as well. In the closing arguments, the defense argued that the Castle Doctrine's defense of habitation applied to Thomas Selfridge, and that he had a legal right to protect himself, just as people were allowed to protect their homes. He said every man is bound and ordered to defend and protect his own life when the government cannot do it for him, which I find resonates a lot today. Further, echoing Hobbes, the defense argued that no law created by civil society may abridge so essential and natural a right as that of self-defense. On the prosecution side, they argued that not only was it illegal to kill in defense of one's honor, the practice was incompatible with liberal democracy. He cautioned the jury against a society in which the would-be noble shall be allowed with his gold-hilted cane or his elegantly mounted pistol in defense of his honor to play a secure but mortal game. Under such circumstances, violent chaos would reign supreme and the volumes of laws would become pavement for the soles of my shoes. Although the defense insisted on Selfridge's natural right to defend both his safety and his honor, the judge's instructions to the jury upheld the duty to retreat. The judge suggested that Selfridge could have escaped Austin's attack through less lethal means. However, his instructions did not resonate with the jury, which swiftly returned a verdict of not guilty. Selfridge went free. So this trial becomes the precedent for all the later cases in the 19th century on the duty to retreat. Is there a duty to retreat in a public space? And this case says, well, actually, not really. It depends on who you're talking about. So this case provides legal foundation for the gradual decay throughout the United States of the duty to retreat. Selfridge's case proved that a man violently attacked in a public place might not be obligated to retreat before defending himself. In practice, however, this was a right reserved only for particular people in specific circumstances.
I mean, you've just sketched out also a genealogy of how a doctrine that allowed some white men, because those white men that owned property, to defend their property understood as a domicile, but also the property of the wife and the children and what slaves they might own, since slaves are also property.
Right.
So this movement from the right to defend your property, and again, people can be property too, that it moves into public space. But what I found so fascinating in the Selfridge case is that the defense is arguing, and Selfridge, I guess, attests to this as well, that somehow were he to have been bested by this 18-year-old, he would have lost his manliness. It would, to lose his manly honor, would actually have made it impossible for him to live, even if he survived the beating.
Right.
So there's something about the property value of white masculinity that's moved with him. So that the logic of property is there in public, at least for that subject whose property rights over his identity are considered valuable.
No, exactly. I mean, I couldn't put it any better myself. I mean, even in the small part that I read, there's an invocation of this defense of habitation, which is really what the castle doctrine is about. It's about your right to protect your domicile. And there's a stretching that goes on here, this epistemological stretching of the defense of habitation to the defense of white masculine honor itself. And there's so many different vectors that influence this in the early republic, one of which I think is the command to spread the influence of European descended Christian civilization from sea to shining sea. There's very much, even in Thomas Jefferson's vision of so-called limited government, which was at the heart of that debate between the Federalists and the Democratic Republicans.
Many of us have seen the musical Hamilton, so go
right,
to it now.
Yes, and I don't think Lin-Manuel Miranda has made a musical yet about the Selfridge case, but I'm going to suggest this is this is his next frontier. But Jefferson, too, even in his sort of doctrine of limited government, was all about expanding the territory itself, like through the Louisiana Purchase. So this was something that became very naturalized once the early republic takes root. So I feel like that's a part of it, too, is the expansion of property. And obviously embedded in all of this is settler colonialism. I don't spend nearly enough time in this book unpacking the naturalized understanding that, of course, these European descended people are going to spread their influence without regard to people who were already living in the territory. So that's part of it too, the naturalized violence that takes place against Aboriginal people.
And yeah, the naturalization too of a notion of property that is alienable, that you can actually sell and trade. And so then the licensed killing of those who have a different view of property, who might not actually see land as property in the same way.
Exactly.
So you can kill those who don't have a notion of property because that's a violation of property, of proper property.
Yeah, or it's a sign of their lack of capacity for higher civilization. Their failure to recognize value and property value, like you're saying, alienation of land as property. So yeah, I think that's a part of it. I definitely think there's an economic principle to this as well. But the sort of long and short of it is, once this case happens, it doesn't take long throughout the 19th century for the duty to retreat to essentially become gutted, but specifically for white men. And there's multiple times where there's appeal to white masculine vulnerability that kind of mirrors what you were saying about Selfridge, the fact that he's kind of weak, that he's not fit for bullying or fisticuffs. Later cases reflect this sense that, oh no, this man is vulnerable, he's a veteran, he's injured or whatever. White masculine vulnerability becomes central to reasonable suspicion of threat. And that's a recurrent theme today, too, is this sort of reverse victimization narrative.
I mean, you just effectively describe, jury nullification as happening, right? So the jury acquits Selfridge in some ways against the instructions of the judge. So, but
absolutely.
And this is about the question of from whose perspective is violence or fear reasonable. So
right.
could you, all right, let's fast forward to the future, which is in some sense back to the future given this history. And are there some contemporary examples about how this question of reasonable self-defense is, perpetuates racial and gender biases?
Right, and that's sort of, I think that's what led me to do this work, is that the concept of reasonable haunts the margins of all these contemporary cases right now. So when we look at what happened to Trayvon Martin 5 years ago, his killer was acquitted based on the jury's understanding of his reasonable sense of fear and anxiety when faced by an unarmed black teenager in a Florida suburb. So this notion of who has reasonable fear, for whom is that fear intelligible, right? So in the eyes of that jury, it was intelligible, it was understandable that George Zimmerman was fearful when he saw Trayvon Martin. I have in the end of the book a bunch of cases. I can read a little bit about the case of C.C. McDonald, I feel, is also a really good sort of illustration of how reasonable fear ends up, in some ways, selectively creating a duty to retreat that continues to haunt certain groups of people. In other words, groups of people that are excluded from that idea of reasonable anxiety and fear. So I don't know if people are familiar with this case of C.C. Alexander. So this was back in 2011, C.C. McDonald in June 2011. Back then, C.C. McDonald was 23 years old. She's a black transgender woman, and she was attacked by a group of white people yelling racist and sexist obscenities. A white woman slashed her face with a glass bottle, creating a wound that would require stitches. In the fight that ensued, 47-year-old Dean Schmitz, a white man with a criminal history, attacked McDonald as she was trying to flee the scene. McDonald stabbed him with a pair of scissors that she kept in her purse. Schmitz died later from loss of blood, and McDonald was arrested and charged with second-degree murder. So we know how all of this ends, but essentially, in the court case that resulted, McDonald maintained, and many witnesses maintained, that she was acting in self-defense, that in fact she was trying to flee this group of people that were attacking her. The prosecuting attorney, Michael Freeman, insisted that McDonald had had every opportunity to retreat to safety. This happened in Minnesota, which is not a stand-your-ground state. So Freeman cited the individual duty to retreat from danger when you're attacked outside the home, right? So McDonald's failure to retreat adequately, therefore, made her a murderer, insisting, quote, that the scales of justice have got a blindfold on them for a reason, end quote. Freeman signaled the blindness of the law to human differences such as race and gender and sex. Thus, he could dismiss the racist and transphobic origins of the attack against which McDonald had defended herself, insisting that the deadly encounter was no different from an ordinary bar brawl, with both sides being equal. In the end, McDonald pled guilty to second-degree manslaughter, and she was sentenced to 41 months. She served 19 in an all-male prison. According to Katie Burgess, executive director of the Trans Youth Support Network, McDonald was placed on trial for surviving a hate crime. So I have a bunch of cases, and I keep seeing new ones. It seems like every time you turn on the news, there's another case of somebody, whether it's a small child or a person of color, a gender non-conforming person who is attacked and fights back, or a woman who is a domestic violence survivor who fights back against her attacker and ends up in prison in spite of being in a stand-your-ground state. So one of my conclusions from this study is that for all the reasons we were talking about before, with the specific coding around reasonableness on which so much of the adjudication of criminal law is based, stand-your-ground laws, in many ways, they don't just not help socially minoritized people and protect them and give them the capacity to protect themselves. In fact, I think they exacerbate the already powerful racial and gender injustices in our criminal and justice system. So in many ways, there's plenty of evidence to suggest that stand-your-ground laws give certain groups of people, usually socially dominant actors, a license to kill, while excluding the vast majority of us from the right to defend ourselves.
But and yet they're cast in the language of being race neutral and gender neutral,
Yep.
as in the case of C.C. McDonald, where
Yep.
the prosecutor effectively says, I mean, this is the kind of the theft of the language of liberal diversity, and we can have, we can talk about this. The law is blind. Let's, in the name, and here's violence being done against this a trans woman. And it's actually, the law shows just how neutral it is by prosecuting her as if her vulnerability wasn't a factor in what happened to her.
Exactly. And it happens time and time again. I mean, there's so many different cases. There's a case of a young trans man that's less well known, Kai Peterson, who's in Georgia right now, serving a sentence in a women's prison. So to add insult to injury, the trans individual who becomes criminalized serves time in the prison of the gender with which they don't identify. And he was criminalized because he shot his rapist. He had a positive rape kit. He had all kinds of evidence in his favor, did not have money to appoint a great attorney. The court-appointed attorney didn't even tell him about stand your ground laws, not that it would have necessarily exonerated him, but we see so many different layers to this. It isn't just about racial exclusions or patriarchal exclusions, homophobic exclusions. There's a class element whereby if you lack the resources to hire yourself a really good defense attorney, you run the risk of being criminalized or having to plead down. And this happens a lot to survivors of intimate partner violence who fight back against their violent partners.
There are so many contemporary examples that you end the book with, and I just want to mention one more, and then maybe open it up to some conversation with the audience and some more back and forth. But this I found to be actually an extraordinary case of Whitley Jones. An African-American woman in South Carolina, which is a stand-your-ground state.
Right.
And she defended herself against her boyfriend, ended up in defense, stabbing him with a knife. He died. Actually, initially charges were not going to be brought against her.
Right.
It was felt that she, in fact, had acted reasonably. Yep. Within the doctrine of stand your ground. And then the state appealed that initial decision not to charge, correct?
Yep.
But what I found extraordinary was what the attorney for the state said and why specifically a charge had to be brought. And I think this actually ties together a lot of the things you've been telling us about this evening. The solicitor for the state, the assistant solicitor, said, quote, "A woman's right to stand her ground in a domestic dispute is less than a man's right to stand his ground with some stranger he's gotten into a fight with."
Exactly.
And that just is the nutshell of,
yeah.
And this is an African-American woman, so she's there at the kind of the intersection
Yeah.
of racism and sexism, and doubly disadvantaged in terms of how the law could possibly conceive her legitimate use of self-defense.
Absolutely. It's a case where I originally was drawn to this case because I saw it as an example of the law working the way it was supposed to, because it was obvious there were witnesses. She had been abused by this man multiple times. She tried to escape. She only killed him when she couldn't get away. And indeed, at the Stand Your Ground hearing, they decided that it was reasonable for her to have acted the way that she did. And then the state prosecutors came after her with guns a-blazing. And that statement summarizes everything, that these laws were never intended to protect women from domestic violence within the man's castle. That instead these laws were designed against stranger danger, really. And part of the the goal of the book is to illuminate the way in which we participate in that sort of fear-generated discourse of stranger danger that then provokes us to think that we need to be individually participating in armed citizenship against all of these different encroaching threats, whether they're criminal thugs or undocumented immigrants or terrorists. There's this whole litany of threats that we're supposed to be afraid of, and yet the actual threats to women's safety are often men they know, and these laws were not designed to protect them. As far as I know, though, Whitley Jones has remained out, free. She's a free woman as far as I can tell. I don't think that the prosecutors were able to get her into prison. So perhaps one example of the law working as it maybe should.
I mean, I think the issue of stranger danger at this particular moment is especially urgent because there are so many different characters who are being proposed as the strangers that endanger us. And I think it's a time to sort of be very watchful of the solicitation of fear and the ways in which people are being, certain citizens are being deputized to perhaps act in ways that are violent towards other citizens.
Absolutely.
And not.
Yeah, whether we're talking about the border patrol or the policing of public bathrooms, which, essentially it's about policing borders and invocations of protection that we started with. And Coverture is an invocation to a particularly racialized, gendered protection of white women. And that's a recurring theme in American history. It justified the lynching of more than 4,000 African Americans, this invocation of the urgent need to protect women. And I see recurrent sort of echoes of that in our fears around bathrooms and the fear that transgressive others are going to threaten women and children's safety in bathrooms. So these are recurrent themes, and I hope that by excavating the history we can be more mindful of them when they crop up time after time.
Let's open it up to conversation and questions with our audience here.
Hi. I guess I'm just wondering, hearing all of this, like, what can be done? Not just like what should be done from like a lawmaker's standpoint, but like what could we do?
Yeah. Do you have any ideas, Professor Pellegrini? I don't, the book is not prescriptive. I don't really have at the end, words of wisdom in terms of what we need to do aside from sort of greater awareness of our past. But one of the things I'm starting to see is that anti-violence work has to think constellationally. It has to be deliberate in seeing violence not just as one thing. So when I wrote this, it isn't just about guns, although guns play, a role in a lot of these stories, these case studies. But to look at vectors of violence as they're connected. So domestic violence, like intimate partner violence, and the way in which that is connected to mass incarceration and the erosion of a social safety net and violent policing and racial profiling, that these things are connected and that we need to become really self-critical about the way in which we engage in certain kinds of practices that become naturalized, like this stranger danger. It becomes often very seductive to imagine that you can protect yourself from terrorists by packing your own pistol, although I don't really know how that works. But it's a seductive narrative that you as an individual can take your safety into your own hands. And so a lot of people, they follow that because it feels empowering. But I think we have to really actively push back against that narrative and think more collectively and constellationally about the sources of violence.
And I also think that some of this is also, what's the language we use to describe actions in the world? And so, for example, whose actions to defend themselves or their communities get called violence? Whose get called justice or defending freedom? And I don't think this is, I think this is actually a really deep question. I don't know what violence is. I mean, I think that what gets named violence is, it's historical, it's context bound. And so we need to sort of not assume that we all know what violence is when we see it or experience it. And how to develop a language, and I think that history really helps here because it gives us, I think, a kind of complicated view of the present, and maybe it could slow down our own reaction time potentially. One of the things that Caroline was talking about when she came to my class today was actually talking about the Black Panther Party and sort of the crucial role it played in the history of struggle for civil rights in this country, and the ways in which that organization has been characterized in some histories of the period as violent, as non-law abiding, when in fact it was actually making use of the law in deeply creative ways that were against white supremacy. But if you have a system organized around white supremacy such that those of us that are white don't even recognize it,
Yeah.
groups that stand up for themselves to fight against it might be experienced by those of us with the privilege of our skin as somehow acting violently against us, when no, in fact, it's actually acting in accord with ideals of justice and freedom, right? So
Yeah.
from whose perspective do these stories even get told?
Right. That's an excellent point about the language that we use, because one thing I noticed is the way in which the language of rioting gets used. In history, incidences that are called race riots actually end up being episodes in which white supremacist violence destroys entire black communities. And it's a gesture that obfuscates entire history. So like the Black Panther Party lives in sort of the wider popular imagination as being violent or anti-white, when in reality, their core principles were about social justice and resistance to white supremacist power and violence. So yeah, so I need to be more careful about how I'm using violence too, but I think absolutely we can all be more sort of self-reflexive as we think about sort of our naturalized understandings of what is violence versus what is justice.
And I think that also, I mean, I love the way that you use these early legal cases to flesh out what's become a kind of obviousness for American, public life. And I think it's also really important not to think that law then becomes determinative of every single way we can think about things.
Right.
Law provides one language, one set of conceptual resources, one tool, but it's not all of them. So what other languages do we get to use outside the court of law? I'm not a lawyer, so in some sense I get to use a different language. I don't have to, sort of cabin what I'm saying in terms of what law will recognize.
Right.
Hi. Do you see a connection between the legal history of stand your ground laws and the legal antecedents of, say, like Trump's immigration policy? Is there a connection between the domicile and an extension of it to the homeland and kind of the preservation of white masculinity in that space?
Yeah, that's a great question. Thank you. So many levels. Yes, absolutely. I don't even know where to start. I mean, there's the one of the necessary factors in the discourse of armed citizenship is about the creation of categories of alienation and otherness and strangerhood. Sarah Ahmed writes beautifully about the conceptualization of the stranger other. Yes, this idea of the security threat to our borders that is especially amplified in the wake of 9/11. And that talk about contributing to naturalized knowledge and insecurities. I mean, in the wake of 9/11, especially right here, in New York City, we become fearful, we become terrified, our borders have been breached. So in a lot of ways, it becomes very convenient to invoke these figures of alienation and danger and use them as justification for draconian and incredibly cruel exclusionary laws. So many different levels, and yes, the sort of invocation of the homeland, the slippage between the sort of defense of habitation and then the defense of the entire homeland. You can see it when you look at Border Patrol too. The deputization of civilians, armed white civilians, to go and patrol the border against so-called illegal immigrants, again, kind of serves that same kind of constellation of exclusion that concentrates power into particular kinds of already propertied hands.
I mean, I was thinking both when you were in my class today, but in sort of reading the book, I was thinking about, and you will know you can tell me the exact quote, but this notion that a good guy with a gun will always beat a bad guy with a gun, and so that one of the things you said is that the ability to identify, we know who the bad guys are, that actually produces the sense of ourselves as the good guy. We need these bad objects out there that define us and our goodness. And I started thinking about this in connection to actually the brilliance and simplicity of President Trump's language during his campaign about the bad hombres, right? Which was extraordinary. And for many of us who are critical and aghast at his policies, and also the simplicity of the speech and the caricature of it, we don't understand how it works. It actually works brilliantly. To just tag in this broad way huge groups of people, and its lack of specificity is actually what makes it work.
Yes.
It attracts. It just, you can magnetize whomever you wish to put in there to be scared of, and then he sort of correlates it to the border and brown people. It's a really actually a quite good use of language if you're trying to produce an us-them division to justify violence.
Yeah, and the kind of fuzziness of those boundaries are deliberate, that almost anybody can fit into that category. I think that's a great point. And that's been a long-standing tradition of sort of the armed citizenship rhetoric, is that those good guys can always tell the difference between the good guys and the bad guys. It's really entrenched in that idea that if only there'd been somebody, a good guy with a gun, at the Pulse nightclub in Florida, if only, then all those people would have been saved. And I think there's a kind of, on a fantasy level, and you're the one who does the psychoanalytic theory, so you can help tease this out a little bit, but I really believe there is, on a fantasy level, people want to do good, and they want to be heroes. And so a lot of this discourse of armed citizenship is about being that hero, becoming your own action hero, where you've got your gun, you're in the right place at the right time, and you manage to take out that bad guy. And that comes up. That's a recurrent theme. The good guys that are going to find the bad hombres and identify them and take them out before they harm the innocent citizens.
Yeah, there is the, if we were going to go with Melanie Klein, the fantasy of the splitting, right? There's the purely good and the purely bad. Because actually it's very hard to live and acknowledge all the ways in which we fall short of our own ideals. Right. And that we actually are aggressive not only towards people we don't know and who are strangers to us and whose differences we might find confusing, but we actually have all sorts of aggressive feelings towards people we love. How do we live with that? Right. Well, one of the ways we live with it is sort of in this unconscious way, I think, and ways that also can be unfortunately manipulated at a larger scale level, is we transfer all those negative feelings that we actually find a bit unbearable and destabilizing. We transfer them onto ready-made objects whom we've learned are safe to hate. And this is I do believe it's possible to live more in the space of discomfort and not have to act out, but there is this way, this splitting of good into bad. It has catastrophic consequences. It's not just lived at the level of fantasy. It is lived, some subjects bear the brunt of being the bad objects, so that others of us can feel like we're good citizens.
Right. So that category of safe to hate is just growing, proliferating right now. Aaliyah, do you have a question?
To what extent do you see this as a uniquely American problem? I mean, when we think about gun violence, I often associate that with, the greater availability of lethal weapons and things like that. But, America isn't the only colonial or imperial power. So, and this clearly comes from English law. So how is it different in the United States versus elsewhere?
Yeah, I think that's a great point. Yes, statistically, in the United States, we have more guns than people, and that's unusual. We have something like 5% of the world's population in this country, but we have almost half of the guns.
So we're overachievers.
We're overachievers. We're totally overachievers. We're also overachievers in mass shootings. We have, astronomically more mass shootings than any other peer nation. Our mass shootings, also another unacknowledged fact about our mass shootings is typically they are enacted by angry white men. And that somehow gets lost amidst the efforts to create these ready-made bad objects that are safe to hate. but I don't know. I mean, I think part of it is corporate. I think a part of it is a very deliberate effort in the past couple of decades by gun manufacturers to find new ways to market the technology, given a waning interest in hunting. Used to be, several decades back, hunting was the #1 reason for owning a firearm. And now people say their #1 reason for owning a firearm is self-defense. So a lot of that perception of urgent fear and anxiety is rooted in, a manufactured effort to create a need for particular commodities. So, but I don't know. I mean, this is the sticky question, is like, why did this happen in the United States? I think it's a whole variety of different interlocking sort of normalized ideas about safety and also individualism. We're like really into our sovereign subjectivity here too. So it's like every man for himself is really big in the United States as well. So
I mean, I think it's such an interesting question, but what you just said about there's a long tradition of the glorification of the individual in the United States, a distrust of the federal government, and you put that together with, I think, this, not only those sort of the kind of targeting of, so who's going to buy the weapons now? So, as a movement away, I mean, there still are large, there's a lot of hunting culture still in the United States, but how do you have to sell more and more weapons. So how do you target those cultivate this new market? But I'm also thinking about how neoliberalism fits into this in the sense of, as the government is, in fact, it's retreating from the provision of more and more services for the public good. So people are being called upon as individuals to do more than they were historically. And you put that alongside an ideology that already distrusts government with a capital G, right? So there's also a fantasy of what's being distrusted, and the sense of the individual who pulls himself up by his bootstraps. I think you have a lot of trends that together would produce an orientation towards gun ownership, and because you use the language, I think it's just hugely helpful of the DIY self-defense.
Yeah, and it is, like you said, it is about self-care given the shrinking of the welfare state. And I think these things are parallel. I mean, that explosion of do-it-yourself security citizenship correlates with the sort of late capitalist retreat from social welfare. So. And one of the symptoms of this is increased militarization. So militarization of police forces, less investment in training, for example, or trying to counteract implicit bias, and more investment in, better weaponry or more advanced weaponry, militarization also of the citizenry, deputization of the, quote, posse on the border. So all of these, I think, are symptoms of that kind of neoliberal turn to self-care that is beautifully compatible with that ethos of arming yourself. Find more guns.
I mean, it goes back to this question, what is to be done? I mean, I think the thing is, people aren't hallucinating. Many people in this country, and not just here, are, in fact, more insecure economically, for example, than they were even a decade ago.
Yeah.
So it's how is one called to respond to that insecurity? With what resources? And whose responsibility is it to help with a shared insecurity? If you individualize that responsibility and you also sell weapons at the same time, I think you've got a recipe for an awful lot of violence.
Yeah.
Yeah.
To pick up on the question about if this is uniquely American, I'm completely convinced by all that you've said and generalizing, but I wonder if you've thought about the nature of the split in the United States historically between urban and rural, and is this really a product of a kind of lionization or valorization of a kind of rural America that has existed since the time of Thomas Jefferson? So I'm thinking, do all these generalizations work if we think about urban populations, which are not as heavily armed, who support gun rights, who probably, most of the examples that you give seem to me are really centered in a kind of a rural population that maybe still hunts, but now increasingly says, no, I need my guns for self-defense. And so, just one of the cases that I think about that maybe goes beyond what you could do in your book is the incident out at the Malheur National Wildlife Refuge about a year ago. And so you
Right.
have these guys who are angry and fearful. They hate the Bureau of Land Management. They believe that they really own this land. And so they take over this federal facility, heavily armed, and and eventually they're overrun, they're apprehended, they're arrested, but within a year they are acquitted.
Yep.
And it happens not in Malheur County or Jefferson County or Harney County out there in rural Oregon, but in Portland, Oregon, which is really weird. So I just wonder if you have reflections about whether there's
Yeah.
a kind of nuance to the generalization about the uniquely American quality of some of these things by looking at the urban-rural split.
Oh, that's a great question. I don't know. I really don't. I mean, I feel like in my book I've got kind of a mix of examples, different cases, and I'm also more recently a report came out on Chicago. Like I think about Chicago in particular as a really interesting case. Illinois was the last state to grant its citizens concealed carry permits. It was the last of the 50. So now in all 50 states you can have a concealed carry permit or permitless carry if you're in one of the 12 states that has constitutional carry. But it's gun violence in Chicago in particular areas is really intractable problem. When you look at the sort of cauldron of underserved communities, withdrawal of social safety net of various forms, gang violence, mass hyper incarceration, racialized incarceration, and police violence, it's a really intractable problem. And so, yes, there is a real difference. The only time I really spend on that difference between the rural versus the urban is in the chapter where I'm looking at African American resistance, armed resistance, and the interesting thing that I find is that we talked about the Black Panther Party, but the precursors were rural. The first black civil rights organizations to be armed and stand up to white supremacy with weapons, all according to the law, happened in the rural South. So like Monroe, North Carolina, and different rural areas in Mississippi and Alabama, and yet we don't hear about those in our history books as much as we do about the Black Panther Party, which gets demonized as being anti-white or violent. So, yeah. And in terms of quote-unquote riots, the language of riots, that's mostly an urban phenomenon as well. But I don't really know what to say then about the sort of difference there between the translation from rural to urban in terms of armed citizenship.
Can you say, did the trial occur in Portland? So I'm actually
That's
curious about the
wild.
jury pool. So because the actual case develops on federal lands and an area one would characterize as rural, but a jury is found and seated in Portland that is persuaded by the self-defense argument given. So it would, that seems to me to suggest that the rural-urban distinction might not even hold. I'd want to know more about the demographics, I suppose, of the jury and how they were selected.
But in some ways, it doesn't even really matter. Like, what I find is that it does, like, often the demographics of the jury don't matter as much as the prevailing ideologies and what's reasonable. So, like in Zimmerman's trial and in many other trials, it doesn't matter. You can have people of color in the jury who still think that it's reasonable for particular social actors to stand their ground or to be fearful in a particular moment. So in a way, I'm not all that surprised. But it is sort of interesting that in the city they would see this as a reasonable set of behaviors. And certainly those folks end up becoming kind of lionized. They become like the action heroes of do-it-yourself security citizenship for many people who believe that that should be our right. Good question. Yeah, Julia. Hi.
So on the topic of juries, I was actually wondering if you thought about the relationship between all of this and the rise of plea bargaining in the United States. So obviously, like, the cases that get the most news coverage have juries, and they're often
Yes.
terrible, but I kind of am thinking, isn't it incredibly dangerous to have defense counsel, and you alluded to this with Kai Peterson's case,
Yep.
that is, like, operating based on their own projections of this bad white jury? Like,
Yes.
how did you find that impacts cases?
Especially with domestic violence cases. And I honestly, this is something, I'm not a legal scholar, so I'm learning as I go. So maybe we can talk about this later, because I'd love to hear more of your insights on it. But a lot of domestic violence survivors will plead down because they're instructed that it's the best way to get out of serving more prison time. So what happens is that influences the shape of our archive. It influences the way in which we see these cases as stand your ground cases, or as cases of something else, whether it's justifiable homicide or excusable, or just straight on criminal homicide. So yeah, people who recognize that in the jury's eyes they are less likely to be perceived as reasonable in their claims of fear will often plead down or be instructed to do so. So again, it comes back to class and resources, and whether you have the money to hire a great defense attorney has a lot to do with it. So it's yet another vector of inequality that influences who's going to end up behind bars for basically exercising their right to defend themselves.
So you've touched on police brutality a little bit, and I'm curious about looking at the historical context you've outlined in the idea of property and this historical definition, and how it kind of gets amplified when a blue uniform is put on. And you can talk about that in terms of something like the Stanford prison experiment, but you can also look at it in terms of the idea of property changing, of the thing you need to protect in a uniform is the public safety. And so it becomes this massive thing that one person is protecting. And I'm curious what you think about that.
A lot of different layers to that question. So if I understand correctly, one is how policing becomes focused around public safety, which is often very much code for protecting property. I mean, often when we see, oh, there's a riot happening in Ferguson, it's the major transgressions that call out law enforcement are when people, destroy private property, whether it's automobiles or stores or whatever, that these are seen as transgressions against public safety rather than transgressions on public safety. So absolutely, there's sort of a call to protect private property, for sure. Another thing with law enforcement, or just what I found historically, I found a lot of really troubling things historically, actually, but one of them was that for law enforcement, it's a much lower bar. In a case of a police shooting, especially of an unarmed citizen, it's a much lower bar for the police to be exonerated based on reasonable fear and self-defense. So when a member of law enforcement claims self-defense after shooting an unarmed civilian, it's easier for them to get exonerated. And it has been for a very, very long time. And this has a long genealogy. There's also a lot of disturbing stuff I found about post-Reconstruction policing in the South, that police forces in southern states proliferated in the wake of Black liberation in response to what was perceived as the threat to public safety of Black freedom itself. So policing emerges in certain southern jurisdictions in response to that. So none of that is really surprising to me, except the extent to which now we have recording devices readily at our disposal. We can record these instances of police violence and still justice is elusive. There was a case just a day and a half ago in, I want to say California, somewhere in California, where an off-duty white police officer basically was trying to hold on to this child, this 13-year-old, I think, Latino boy, and ended up in the end pulling a gun on him and shooting. Didn't kill anybody, thank goodness, but the 13-year-old boy and a 15-year-old friend who was trying to intervene are facing criminal charges. The police officer so far hasn't been charged with anything, but if you look at this video, it's shocking. This is an adult, grown man brutalizing a small child. It continues. And I don't really know what to say about it, except yes, it is absolutely imbued with notions of property and who has the right to own that property and protect it. I think the reason the man was attacking the child was because the child had been on his property. So it comes up again and again and again.
Yeah, I think that this. I was almost about to say, can we have a happy ending? But I actually think that that would be to turn away from what I think is the urgent and sobering and just such important argument of your book. And that, in fact, history has many things to tell us about our current moment and which bodies can be safe, which bodies can be targeted for violence, including lethal violence, and which cannot. And it's not about a happy ending. It's about making better futures together. And so.
Right.
Dr. Caroline Light, thank you for being in conversation with me this evening.
Thank you,
and please join me.
Thank you so much.
And I'm told you will happily sign copies of your book. Actually, and she will actually, in the service of selling books, sign any book that you buy here at NYU Bookstore this evening. Any book.
Any of these books on legal theory and evidence.
Thank you so much, Caroline Light and Ann Pellegrini. Thank you all for being here. We also have a book that Ann Pellegrini had co-authored. You can tell just by looking, and 20 other myths about LGBT life and people. Both are on sale this evening, and we thank you for being here and hope to see you again soon. And may we have peaceful times. Thank you.
Here's hoping. Thank you.